To create a will or a trust, you basically need two different things to come together, and I refer to them as formalities and intentionalities. Formalities are really just the form of the document itself. So a will, for example, it's one of the last legal documents that requires some very specific formalities on the document itself. So, for example, it has to be in writing. It has to be signed by the person who's creating the will, who we call the testator, and it has to be witnessed by two witnesses. Now, the interesting point is wills are never notarized, and a lot of people don't know that, but that's the formalities of creating a proper will. For a trust, it's a little different because a trust doesn't have all those formalities. A trust actually can even be an oral trust, although that's very rarely the case, and you normally wouldn't want to create an oral trust, but you could. And for a written trust, it's very simple. You have a written document and you simply sign it. Trusts typically are notarized, but that's not one of the requirements for a valid trust necessarily. So those are the formalities that you have to follow. But you also need intentionalities, and that is that the person who's coming to create the will or the trust, they have to intend to create that document. And there's a number of things that can stand in the way of that intent. So for example, a person could lack capacity, and if they lack capacity, then they wouldn't have the intent to create that document. There also can be things like undue influence. So if a person is creating a document out of the undue influence, then it's not a validly created document. There can also be fraud, and there can even be duress. But if you have somebody who actually creates a will or the trust, they express that intent to create the will and trust, and they're not suffering from any of the capacity or undue influence or fraud type issues, then you have a scenario where you can have a validly created document, whether you're creating a trust or a will.